The information provided on this show does not, and is not intended to, constitute legal advice. Instead, all information on this show is for general informational purposes only. The information provided is not a substitute for legal advice, and we recommend viewers consult an attorney for specific legal matters.
Good morning. Welcome back to Condo Craze and HOAs here on our YouTube channel. This is Skippy, the show mascot.
Hey, Skip.
It's Eric Glazer. She's here every Sunday, as we are, to answer your questions about anything making you crazy in your condo or HOA. Today we're talking about old people. I'm Karen Curtis, and that's Eric. He's the attorney. So we are actually
you said
talking...
old people, and then you said, here's Eric. That was very nice. It was great.
The old fart here. 55 and over communities in Florida. If you live in one, you may not really be living in one.
Yeah,
Take it away.
Exactly, yeah. Let me start with a question for everybody. Imagine you bought a unit in a 55 and over community, right? Everybody moves in there because they love the quiet light and then the lifestyle and the peace and quiet and the rules that keep it that way, right? But then one day, what happens? A family with 3 kids move into the building, and when the board tries to stop it, they're potentially told something shocking. Your community might not legally be a 55 and over community anymore, after all, and it's not because your documents suddenly change, and it's not because the law suddenly changed, but it's because your own board failed to follow 3 very specific rules, and if those rules aren't followed, that age restriction that you think is in your community suddenly may be completely unenforceable. So today we're going to break down what those rules are and why many communities in Florida may already be out of compliance as a 55 and over community without even realizing it, Karen.
I mean, Florida's got to be the 55 and over capital of the world. I live in a 55 and over community.
155-year-old capital of the world. And I agree, but here's the part that a lot of people don't realize. A 55 and over community is actually an exception to federal housing law, to federal discrimination law. Normally under the Fair Housing Act, you cannot discriminate against families with children. You have to let children into your community. But Congress passed a very narrow exception to that law called the Housing for Older Persons Act. That should make everybody feel good, right? And that law allows communities to prevent children under the age of 18 from moving into your community.
Unless you have somebody over 55 already living in the unit.
That's what you're going to have. But the association has to follow 3 strict requirements. Miss even one of them, and the entire exemption can disappear.
But we're old, we forget.
Yeah, that's true. You better not forget.
Oh.
That's what we're teaching everybody today. Here's the biggest myth that boards believe. They think, hey, we're a 55 and over community solely because it says so in our documents, and that would be wrong. Your docs alone do not make you a 55 and over community. The law does, and the law requires active compliance, meaning if the board stops enforcing the rules or stops tracking the requirements, you could lose that protection under the law. And let's talk about rule number 1. A lot of you know this one, and it's the 80% requirement. At least 80% of the occupied units have to have one resident who is age 55 years of age or older.
That's a lot.
Yeah, now that 80% is a big number, that's true, but notice something important. The law says occupied units, not total units. That means if the units are vacant, they are not counted.
You know, and that's got to go up and down.
Yes,
and
it
it's
does.
hard to, keep a meter on all of that. And does the age of the owner matter?
No, and we get questions like that all the time. I get calls from the 55 and over communities I represent. Someone who's 40 wants to buy a unit. Can
They
we
don't
let
even
them?
have to live in there.
Exactly. It doesn't matter. The age of the owner doesn't matter. Notice the age of the occupant is the key factor here, not the age of the owner. The owner can be 18 years of age. It's completely irrelevant. But here's where the board makes mistakes. They stop tracking who actually lives in the unit. So what happens? Someone rents to a younger couple, another owner lets their kids move in, another owner has underage long-term guests that never leave, right? And suddenly the math starts shifting. And if that percentage drops below 80%, even temporarily, that community, you can lose your protected status under the law. And here's the scary part. Once that exemption is lost, it doesn't automatically come back. And believe it or not, that 80% rule is not the requirement, though, that even causes the most problems. The rule that gets the communities in the most trouble is rule number 3, but you're going to have to wait to get there in a few minutes.
Not rule number 3.
The second requirement to be a 55 and over community is something called intent. The community has to demonstrate the intent to operate as housing for older persons, and that usually means your governing documents clearly say it's a 55 and over community, but even that alone is not enough. Your policies, your enforcement, your leasing approvals, they all have to reflect that same intent. If the board stops ignoring these rules or enforcing them selectively, guess what? Courts can determine that your community no longer qualifies. Your good intentions, not enough.
So
compliance is what matters here.
So you could be at 80% and you're not complying because it's not in your documents, or you have.
And you can still lose.
And you can
we'll
still.
talk about that in a second, how all the things you need to do to comply. Now let's talk about the requirements that most communities ignore when it comes to compliance, Karen. The law requires age verification every 2 years, proof that there
Every
is at
2
least
years.
one person age 55 and over from living in the unit. And that means the association must confirm the ages of the occupant and keep written records proving it.
Because we're old, we die off too.
Yes, that's true
gosh.
too,
And
right.
How are they supposed to do that with the written record?
This is what they're required to do. They have to go and get copies of driver's license, passports, birth certificates, even affidavits, something that shows the age of the resident, showing that there's at least one person living there age 55 or over.
They can look at your teeth too.
Not enough. No, that's not in the statute, Karen. And if someone challenges your community's 55 and over status, you better be able to produce those reliable surveys.
So you
It's
have to
called
do a
reliable
census
surveys.
every 2 years.
Reliable
A census.
surveys
A
is what it's
survey,
actually
okay.
called, reliable surveys. And you better be able to produce the records, because in the eyes of the law, if you can't prove this compliance, you are not compliant. And I've seen communities that haven't verified ages in 10 years. And I can tell you what, even when they have a management company, the management company
Right.
isn't doing it, and it's a serious problem.
It is, but you may go below 80 and above 80 and not even know it.
Right,
You may
exactly.
be out of
Which
compliance.
is all the more reason why you have to take these
Every 2
reliable
years.
surveys every 2 years.
So, and those communities still think they're protected, and it turns out till someone files a fair housing complaint,
And that happens.
it
That
happens.
happens. Yeah. And when that happens, the consequences can be really serious. If a community now tries to enforce the age restrictions without meeting those federal standards, like taking those surveys, that community can now face fair housing complaints, federal investigations, costly litigation, forced policy changes, meaning now you're going to be forced to take children in, and attorney's fees against the association. And in other words, the association might wind up paying tens of thousands of dollars just because the board or management company failed to follow the law here. So if your community claims to be a 55 and over community, the real question isn't necessarily what do the documents say. The real question could be, can the association prove compliance? Because if the board gets that wrong, they don't just lose the age restriction, they expose the entire association to liability. And if you're not sure whether your community meets those requirements, now is the time to find out before somebody else does, and you learn the hard way. Okay, so do you have questions about your 55 and over community or anything else in the condo and HOA world? Give us a call in the studio here, 917-452-9378. Again, 917-452-9378, or that's 917-Glazer8, or drop us a question or comment in the chat box on YouTube. We'll be back right after this.
Paul thought being on the board meant volunteering.
We demand this pool open now!
Now he's somehow in charge of a construction project larger than anything he's ever owned.
Your top concrete layer of your pool deck all needs to be removed so we can waterproof the structural slab. It's all very simple stuff. You do understand all of this, right?
I understand.
He doesn't, but HCMC does. Save your weekends, sanity, and suntan. Let us manage the mess. Call us to discuss your project at 954-805-5235.
There are very large management companies, and there are very small management companies. And I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
So welcome back to Condo Craze and HOAs. This episode is devoted to the old people like me.
I'm over
it's so
55 now, that's for sure.
Betty Castanga says, at least we're talking about humans in our no pets building. We've been overtaken by dogs.
Well, I'll tell you
like
something.
Skippy.
I've learned something. I've said this a long time now. When it comes to being overtaken by dogs, you say, people will fight for the death. They'll spend all kinds of money for the right to keep their dog. Their spouse, not so much.
Oh, yeah. Or the
right?
kids.
The kids. Right. You can take my spouse.
We don't need the kids in here.
But my dog, don't you dare. I'll spend whatever it takes. A lot of good questions actually on the board this morning. Macleghome writes in, is an NDA something a board should consider for members, or is an ethics policy more appropriate?
NDA.
It's a non-disclosure agreement. I'm not sure what you're referring to, but let me turn it around a little. When sometimes a board will settle a case, right, with a unit owner, and one of the parties will request a non-disclosure agreement, meaning we want this settlement agreement to remain confidential. And I can tell you that if there's a settlement agreement drawn up between an association and an owner to settle whatever kind of dispute it may be. If it's in court or even if it's not in court, that agreement in and of itself is a document that any unit owner has the right to see.
Oh, so no
right.
NDA.
Right. So there's no way that you can keep that document confidential. That I can assure you. Rob, how about we take our
Wait.
first
There's
one?
one.
Okay,
A live
who do
off
we got?
center says is the 2-year census, but you call it a what?
Reliable survey.
Reliable
Yes.
survey. Kept on file with the association, or is it submitted to whom? Which is a
Just
good question. Does it
kept
go to
on
the
file.
DBPR?
No. Just kept on file.
So it should be
That's
on the
it.
web?
It does not have to be on the web, no, but it does have to be kept by either the board or the management company, so that if somebody challenges your policy and say, you know what, I don't believe you're a valid 55 and over community, show me your census, right? Show me your reliable surveys. You better have it. If you don't, then you can be challenged. You
Here's
could lose
someone-
the exemption.
Jill Sivert says, we have a person that wants to buy 55, but only live there part-time, and the 20-year-old son will be there full-time.
No, if he's going to be the full-time resident, no. Should that be allowed? Absolutely not, okay? No. Now, can that 55 and over occupant, for example, let's say they live here only half the year, can they go back to, you know, if they're snowbirds, go back somewhere else for the other half the year? Of course they can, as long as if there's an intent to return. That's
But
fine.
then it's vacant.
But then it's vacant, right?
So
then
that
it doesn't
doesn't
count.
count.
Doesn't count towards the math.
Or
But they
the-
better not put somebody in there for those 6 months in that unit who's not, where there's not at least one person 55 or over.
Or the 20-year-old son could have a May-December relationship.
I wouldn't want the son there for 6 months a year by himself. That could blow the exemption as far as I'm concerned.
Even with a 6-year-old girlfriend?
Oh, that's a different
May,
story.
December,
Oh, that's
when-
and it's fine. Yeah,
May,
yeah.
December.
Yep, the cougar can remain. Absolutely. Now can we go to the phones?
I'm sorry.
Yeah, who do we got?
Let's go to John in Hollywood.
Hey,
Yeah.
John.
Yes, good morning.
Good morning.
I have a question. Can a condo association require that 100% of the units be occupied by someone 55 or older?
That great question. And that 80% number is just a floor. That
Wow.
80% number, right, just qualifies you to be a 55 and over community. Yes, the association can say 100% of the units must be 55 years of age or older. Absolutely. There's nothing wrong with that. Okay?
Okay, that being said, suppose there's someone occupying the unit and no one in the unit is over 55, but
Right.
they represented that they would have someone over 55, but that there's not a person over 55 living there.
Okay.
What can the board
time to
do
get them
about
out. Time to file suit against that owner, right? Saying that they are violating the declaration. They're jeopardizing the status of the community. They either get somebody age 55 or over in that unit, or we kick out the people that are currently living there. Period. And that's not uncommon. That happens all the time. Yesterday, for example, wrote a letter to a unit owner who was not having somebody age 55. No, who actually had children in the unit in violation of the 55 and over rule. But that happens all the time, where if the unit is not being occupied by at least one person age 55 or over, then yes, it's time to sue that owner, because if you don't, let me tell you, you could lose that exemption. Is that what you want to do for the rest of the community? You want to endanger the rest of the community?
So as long as you have a lawsuit going against someone, then
Yeah,
you're okay.
You
That's
better do
intent.
something. Yes, that's intent. Exactly right, Karen. Okay?
Okay.
All right. Hope that
Very good.
answers your
Thank
question. You got it.
And go Yankees.
You're damn right, go Yankees. Way to go.
Is it opening
Thank
day
you.
today?
No, it's not. On the 27th, I think the Yankees open. All right. Who's the next caller?
All right, over to Panama City.
Oh.
Panama City. How are you?
Good morning.
Good
Eric.
morning.
I'm doing well. Thank you for taking my call. My
Sure
question is not about a 55 and older community, but I had a situation here where the former secretary of my condo repeatedly refused to provide condo records when she was in office. Now, her term ended this past November, but when she was on the board, I filed a complaint with DBPR, and they didn't penalize the board, but they did issue a letter of guidance reminding the board their legal obligation to provide records. Well, after that letter of guidance was issued, The secretary continued to not provide requested records and even resorted to simply refusing to sign for certified letters that I sent her. Now, my reading of Florida Statute 718.111, Section 12C2 says that willfully, knowingly, and repeatedly refusing to provide records is a second-degree misdemeanor. So my questions
sure
for you
is.
are, one, is it a misdemeanor? Two, if I file a new complaint in the DBPR, do you think they would take action against the former secretary, given that she's no longer on the board? And three, if the DBPR would take action, would the DBPR's action be against only the former secretary who committed the crime, or would the current board be in some kind of jeopardy because of it?
Okay, so to state the obvious, the DBPR can't file criminal charges against anybody. So what you may want to do, right, the only ones that can file criminal charges are in the state attorney's office.
Yeah, I don't think the police would touch this one.
But the state attorney's office might. I'll tell you, it depends what kind of who the state attorney's office is, quite frankly, in your community. They love going after these types of cases now. These cases get a lot of publicity. Let's put it this way. That law was passed for a reason. And what makes it very interesting in your case is you had the DBPR already warn her, right? I mean, you really have some good proof there that there was a warning that went out.
Right.
And then if you could prove that they did it again, that the same person did it again, if I'm that secretary, I may be a little nervous right now that the state attorney's office can come after me. Maybe they want to make an example of somebody. I'm not telling you to do it, but I'm telling you that if you did, in fact, show them that the DBPR previously warned her and she did not heed their warning, then yes, they may actually take the next step forward and file a criminal charge.
But is there a statute of limitations? She's not on the board anymore.
But she was. You're saying when she was on the board, she did this even while she was still on the board a second time. Is that right?
That is correct. She was on the board the second time.
You know what?
She's now off it. But I do have a follow-up question. I would be very surprised, Eric, if the state attorney would prosecute this. But does DBPR have the ability to, at the very least, prohibit her from ever serving on a condo association board again?
I don't think they can, to tell you the truth. I don't think they have the ability to do that. But they do have the, under the statute now, if they believe that a crime has been committed, they're now required to refer that matter to the state attorney's office. I know that. So,
Okay, so I should
you can
to DBPR
start there
and then see if they turn it.
They might, if they're following the statute. I think they're required to now. So they certainly might, but it would be interesting to see a state attorney's office actually run with something like this, because that's why these laws were passed. I mean, why pass them and make a whole big deal about them and give it all the press that it got if no state attorney's office is ever going to enforce these? So it'd be interesting. I'd like to see how it went down.
Yeah.
Yeah, well, there is prosecutorial discretion, and they may think it's not that big of a crime.
Understood. Well, it depends. In Miami, it might not be, but in Panama City, right? Maybe things are a lot better than they are here in Broward and Dade, right? And maybe the prosecutor over there can do it.
Once they finish prosecuting all the underage drinking from spring break, they can get to it.
I get it. That's right. Hey, thanks for the call.
All right, thank you,
really
Eric.
appreciate it. Okay. Keep them coming, Rob. Who do we got?
Let's go to Delray. Joe, you're live.
Hey, Joe. How are you?
Hello, this is Joe from Delray Beach.
Good morning, Joe.
Good morning. Karen, good morning.
Morning. Eric.
Good morning.
Well, he said good morning first, so understood. So I have something that maybe I never heard it asked before. In my community, I'm the president of my board, and a couple of years ago, some residents formed for want of a better word, a good givers club. And what they brought to me was that this good givers club would get donations from activities and from unit owners, supposedly inside the community only, and purchase certain things for the community.
Okay.
Now, this has gone on. It was very benign. It was small things they would purchase. I agreed to it, but it came to a head last week when I started thinking, instead of the Good Givers Club coming to the board or to me and telling us what they want to enhance, I'd like to tell them what we need. Well, the first thing I did was ask for some disclosure and transparency. How much money's in the fund? Do you have a check? Everything's cash, by the way. All right. And I started, this has been bothering me for about 6 months now. So I did ask the questions, and they went ballistic. They will not divulge any information. They don't want to, they took it as they took it the wrong way, like I was probing. So I started thinking into this deeper, and to me, it sounds like they're collecting money from unit owners, only a certain amount of unit owners, I'm sure, and they're purchasing things or, enhancing things for the community. But these are things that we already have line items for in our budget, and people are already paying for. So I want to terminate this and not allow it to go on anymore.
You can't. You absolutely can't.
Do you have an opinion?
Yes, the opinion is that you can't, and you can't ask them for access to any of their documents, and you have absolutely no say in what that organization does or wants to do. It's something separate and apart from your board of directors, and there's case law right on point from there's arbitration case law right on point that says when you have a club, right, that's totally separate and independent, right, from the association, right, and the bottom line is you have no right to ask them for their records or their meeting minutes or how they spend money. And if they want to give a donation to the association, I think I'd rather say thank you, right, and I really appreciate what you're doing.
Right, which we have, and none of what they've done has gone, unappreciated. But am I wrong in asking them to purchase things that we need rather than them deciding what we need? And
you could suggest that to them, but what's the saying? Don't look or get tossed in the mouth.
Yeah, when you give to a charity, you're not telling them how to spend the money.
No,
right.
Of course not.
But we had a similar thing, but it wasn't a club. It was when we first moved in. They're like, you have to give us $50,
right,
and a check. And I didn't know what it was for.
Right.
They wouldn't tell me what it was for. And now that we have an attorney who's the director, it stopped. Because I was like, I don't want to pay.
Right, if you didn't know what it was for, I get it.
$50. I need you $50. What is it for?
There are social clubs, for example, right, that collect money to do things with the unit owners, go on trips or go whatever it may be. The board has absolutely no authority to ask for any records from those types of organizations, those types of independent clubs. So can you ask them, can you say in a nice way, hey, I'd like to work with you guys, or really, don't get me wrong, I really appreciate what you do, but would it be okay if you asked us what we need and we told you, and we'd give you credit for it. We'd write you up in the newsletter that we send out to the community. We'd show our appreciation. Maybe it's how you approach it.
What about a suggestion box?
Yeah, or sometimes it's just a matter of how you approach things, right? Yeah. But to say that I want to see their records and stuff, no, you don't get to see any of that. Okay.
So they're opposed to being called a club. They prefer to call it a fund.
See, that's what they called ours, a building fund.
Whatever it is, 6 of one, half a dozen of the other, I don't think it really matters. But I think they're doing something nice for your community, actually. Okay?
And they are.
Yeah.
I agree.
Okay. All right. I'm glad we agree on that. Okay?
Okay.
Thanks
you very
a lot.
much.
Okay. Who else we got, Rob?
All right. From Delray to Sarasota.
Hi.
Carlton.
I'm going to start a fund.
You're live.
Thank you. You've answered my.
Oh.
Yes. Go ahead.
You've answered my question online.
Oh, good. Thank you.
It was on the census, but while I have you, I seem to be having trouble syncing the video. When I have you on the phone waiting to answer a question, my video stream seems to lag. Is there any way I can sync that better?
No, there's a delay from live to what you see online. There's a delay.
Well, it's good seeing your faces every week. I love what you're doing.
Thank you so much. Appreciate it.
Hard work.
Thank you very much. Thanks so much. Next, well, let's take one from the board. Let's see. How does a board determine if a mortgage is current? Let's stop there. You don't know if a mortgage is current. You have no idea unless you get served with a mortgage foreclosure complaint.
Right.
So in every single foreclosure complaint, the association is named as a defendant in that foreclosure complaint. Why? Because the bank tries to wipe out any amount of money that is due to the association. And typically, can they wipe it out? Let's just say they typically have to pay the lesser of 1 year of assessments worth to the owed to the association, or 1% of their mortgage. The overwhelming amount of the time, it's 1% of the mortgage. That's the only thing that they're required to pay. And that's typically when you know whether or not that mortgage is in default, when you actually get served with a foreclosure complaint. When you get served with that complaint, you can see what the bank is suing for, right? How much money is owed on that mortgage. And then you can make a determination as to whether or not that house, if there's any equity in that house, and whether or not someone's going to be bidding on that property at a foreclosure sale. Okay? Back to the phones.
Well, here's a good one. Condo Doc says, all people who live in condo must be 55 and older. Can a daughter under 55 live in the unit? Well, yeah, if you have someone over 55.
As long as there's one person over 55.
But by herself, no.
No, but by herself, no. But can the daughter who's over 18 live with the parents? Absolutely, they can. Nothing wrong with that.
What if she's under 18?
If she's under 18, no. Not do it. Over 18, yes, she can. Okay?
That's draconian.
No, well, that's when you choose to move into a 55 and over community.
So that's why I don't see any kids.
What about, right, what about when the parents move in, they're both under 55, they let their daughter move in, who's 30, and then the daughter suddenly gets pregnant.
Oh, boy.
Now what?
Now what?
Now what?
Well, if they allow the dog, it's good.
That child cannot stay. That's the reality. That child cannot stay under the law. That's how it works. Back to the phones, Rob.
All right, over to West Palm Beach. The name is not clear here, but if you hear a beep, you are live.
Hi, this is Faith. Good morning.
Hey, good morning. How are you?
Good, good. I have a question about the over 55. I'm president of my condo.
Sure.
And I have 2 board members. They own 2 units. In their second unit, they moved their son or daughter and son-in-law into the unit, 30-something-year-olds, and they now have a baby.
Oh, boy.
It's
yeah, and I tried to, address it with them directly, and was told that, there's that 20% exception. And I'm like, but that's not if you move in.
That's correct. Those exceptions are generally reserved for those instances where, let's say, a husband and wife buy a unit in a 55 and over community. The husband is 60, the wife is 50, and suddenly the husband passes away, right? You don't want to force that 50-year-old wife into the street now, right? So she would fall within that 20%. She gets to stay. It's not where, hey, I'm on the board and I'm going to bend the rules to allow my child to move in. Absolutely not. Right. That's not why it's there. And that's why someone asked before, is it possible to make it 100%? And the answer is yes, it can be 100%. But in those situations where you still have that 50-year-old wife, you're not going to be able to kick that 50-year-old wife out.
How can you find out what it says, 80% or 100%? And
it's in your governing documents.
Okay.
Yeah, it's in your governing documents, right?
Right.
But so you're in a spot. Those other board members of yours put you in a spot that they shouldn't put you in. But you now need to go and talk to the association attorney and tell the attorney what's going on and get an opinion from the attorney about what you should do next. Do they constitute a majority of the board?
No. There's 2 of them. There's 3 other board members.
Well, the other 3 should vote to take action, period.
Yeah, and I have talked to the attorney. So I have to, how long should I give them to move out?
You give them 60 days at the most.
Because that threatens the whole community, right?
Exactly. 60 days at the most. Put it on record. Yeah, absolutely. It threatens the entire community. And the nerve of them to put you into that situation. Right. Okay?
Right.
Yeah, terrible.
Well, we have a lot of investors. Yeah. So now I've got investors coming saying, well, if they can do it, we can,
absolutely.
We can
look at the Pandora's box now that the other board members, opened up now. So they the community should know exactly what they did, quite frankly. Totally wrong way to go. They jeopardized everybody.
Right, and it's on the board meeting agenda for tomorrow.
There you go. I wish you luck, okay?
Thank you.
All right, thank you. Let's take our bottom break of the hour, taking the calls coming in, keep them coming in. 717-452-9378. Again, 717-452-9378. Or drop us a question or comment in the chat box on YouTube. A lot of good ones today. We'll be back right after this.
In South Florida, the transition from bright sunshine to heavy rain and hurricanes can take a toll on your property's exterior and structural integrity. Cracked stucco, spalled concrete, they're more than eyesores. They can signal deeper issues. Now, with new Florida laws involving structural integrity requirements, we want to help you meet your milestone inspections and maintain the durability and beauty of your building. Since 2004, PD has been the trusted expert in structural concrete restoration, painting, and waterproofing for condominiums and commercial properties. Visit pd-concrete.com or call us today.
All over the world, people have plumbing problems. These problems can be expensive and destructive to fix. Have you ever wondered if there was a way to take care of your plumbing problems without destruction and an outrageous price tag? Welcome to Pipelining Technologies, Inc., where we specialize in fixing your problems without demolition and minimum cutting by means of pipelining. Pipelining is the ability to take a pipe damaged by root intrusion or long-term deterioration and make it new. By means of inserting an epoxy-saturated liner into the pipe and allowing it to harden or cure, leaving behind a brand new pipe.
That sounds great. How can I get pipelining in my home, commercial building, or condominium?
Simply fill out our online contact form and a pipelining representative will get in touch with you in a timely fashion, or call us directly at 561-853-5463.
Welcome back to the second half hour of Condo Craze and HOAs. Karen Curtis with attorney Eric Glazer. We are talking about 55 and older communities on this show.
So let's see. Someone writes in. Timothy writes in and says, Karen drank too much coffee this morning. Give me that. That's pretty funny. I like that. All right, back to the phones.
Does that mean you want me to shut up? Yes.
Back to the phones, Ron.
All right, let's go to Ocala. Linda, you're live.
Ocala. Hey, Linda. Linda, you there?
Turn your audio down. Yeah.
Turn your audio down, Linda. 5, 4, 3, 2, 1. Okay, somebody else. Who else we got, Rob?
All right, let's go to, back to Delray. David, you're live.
I guess that's people who like to hear themselves speak, right?
Hello.
Keep their volume. Yes. Is David?
Yes. Yes. My apologies. I came in a few minutes late to the presentation with regarding reliable surveys.
Yes.
How specifically do you conduct them? Is door to door? Is it mail?
Yes.
Mail,
Why not do it? Why not do it door to door?
How?
Yeah, do it door to door.
And what can you ask? And what can you not ask?
So you can get copies of any government-issued identification, actually. So let's say you can ask for a driver's license, something that shows the age of the person, right? Driver's license, passport, birth certificate, something that shows there's at least one person in the unit age 55 or over. Failing to take these reliable surveys, and you're doomed as a community. And again, not to pick on management companies this morning, but I'm surprised how many management companies don't know this, and they're managing 55 and over communities. This is really important stuff. If you don't do it as a management company, you can cost your association that you're managing, you can make them lose their exemption that they get under federal law.
Shouldn't it be from the board's direction to the management company?
Yeah, but they're looking to their management company to advise them on that. I know that management companies are not supposed to advise on the law, but if you're managing a 55 and over community, you should know that every 2 years you have to take reliable surveys.
And
you should know
the board should make sure they are.
Absolutely. Yeah, they should know that though. Okay?
As part of my application package, on my application, I certainly ask for date of birth, okay, along with other relevant information.
Yep.
So if I do the survey through the let's call
fine.
them resident files,
Yeah,
is
that's
that
fine.
sufficient?
Yeah, that's fine. As long as you're doing it every 2 years, as long as you're doing it when somebody moves in, you're getting proof that the person who's buying and who's going to be occupying. Says, I made a mistake there. I said the person who's buying, the person who's buying is irrelevant, right? For example,
I have all that information.
So hold up. So let me give you a situation where it happens a lot potentially, right? Children who are in their 40s, right, want to buy a condo unit for their parents who are in their 70s, right? The children could be, like I said, in their 40s, no problem. It's irrelevant how old they are. But their parents who are going to be moving into the communities have to show the association proof that at least one of them are 55 years of age or older. It's the occupant that counts. Okay? All right, so make sure you're taking those surveys.
Okay. What if on my application one person is 55, the other isn't, which is fine under fair housing.
Right.
Okay. And that 55 and older person does not move in. Okay.
Right.
But the under 55 does.
So that's typically happens, a scam is pulled on the association, right? So that approval is given. And that, someone called before about what happens when they had people on their board that did the same thing, right? That they allowed people to occupy the unit knowing that there's no one there that's 55 years of age or older. Time to sue, period. Happens all the time. Time to file a lawsuit, because if you don't, and if you let people get away with it, you will lose the exemption. When you try to sue somebody else for it later on, what is that person going to claim? Selective enforcement. And you will go down, you will lose the exemption, and guess what? You will now have to start allowing children to move into your community. Not what you want to do. And if you don't think it can happen, think again, because it can. Okay? Thanks for the call.
What if?
All right, let's move on to the
Thank you.
next, okay?
Bye now.
Thanks, Ron.
If an association changes the law firm who's represented them, does the board have to tell the community?
Well, yes. The bottom line is that law firm who is being hired, it should be voted upon at a board meeting to hire that law firm. Absolutely. The people should know who the association, who the board is choosing to hire as their new law firm. Absolutely. Okay.
And
back to
And do they need to get competitive bids for that?
No, they don't. That's right. There's an exception. So normally you got to get competitive bids when you do, all these different things. So when
Of course, the lawyers.
Right. And you know what? Right. You know why you don't have to get competitive bids for lawyers?
Why?
Who wrote the law?
That's right.
Exactly. And on that note, let's take our final break of the hour. Keep the calls coming in. 717-452-9378. 717-452-9378. Back right after this.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project. Visit us online at dmipavingandsealcoating.com.
So welcome back to the final segment of Condo Craze and HOAs. Don't wait till the very end to give us a call. Phones are stacked. Also, you want to talk about your seminars?
The seminars are coming up. I don't have the dates in front of me.
They're all in April.
Yeah, Rob, you have a graphic, I think, for that, right? But remember, guys, if once you get on the board, you got 90 days to get certified. If you don't get certified within 90 days, now by taking an educational class, you are automatically off the board. One way to get certified is by taking our educational class that I've been teaching, I think, I don't know how many years now,
You
15 or
invented it.
more, and was the first one to design a course, first attorney to design a course in that regard. And we teach a million different topics, everything that not only that the state requires you to know, but believe me, a lot more. Those of you who have taken the course always call in with wonderful comments. They say they like it, and we feed you. So there's no reason not to come. The classes all start at 8 o'clock in the morning. They're all part of the L&L Condo and HOA Expo, and we're going to be teaching it all over the state. Robert will put up the graphic if you'd like to register for them. Great. Just make sure to go to Condo Craze and HOAs.com, Condo Craze and HOAs.com
Plus, you have to take
register. It. Yeah, I mean, the bottom line is you do have to take an educational class now. Why not take ours? And I love meeting anybody. I really, really do love meeting everybody. Okay, on that note, back to the phones.
All right. And I don't see a name for you, but if you hear a beep, you're live.
Pierre here. I live in a condo which has had zero amenities for over 3 years.
Oh, say that again. I live in a condo with what? Say that again.
Zero amenities.
Zero amenities.
The pool hasn't worked for 3 years, for instance. There's absolutely nothing going on. We'd like to sell and get out of here and maybe move to a condo that's just a bit more pleasant. And so a couple of years ago, we did a survey of all of the units, found that about 60% of the people were willing to stop at 55 plus.
Okay.
But the president at the time refused to do anything with it. And actually, I'm a Canadian, so I was moving back home for the summer. So nothing happened. And I'm wondering, what do we have to do? There are some of the things that you mentioned today, for instance, people under 18.
Right. Well, this is an interesting question. What you're saying is 60% of the people no longer want there to be a 55 and over community.
Whoa.
Right. Well, what do we know that if you're a 55 and over community, when it's time to sell, right, the pool of people that you have to sell to is obviously much more limited, right? And some people say, you know what, and we just don't want to be a 55 and over community anymore. So what do you have to do? You have to amend your governing documents. And how do you do that? You got to take a look at the provisions in your governing documents, in your declaration, that talk about amendments. Typically, it's 2/3 to amend your documents or 3/4 to amend your documents of everybody. And if you can get that vote, 2/3 or 3/4 to change your community from a 55 and over community to a non-55 and over community, it's that simple. That's it. That's what you need, a vote of the community.
Or just don't do anything and wait.
Right. Now, now you are at 60%. That's probably not enough in most communities. Most communities at a minimum is 66 2/3%. But you were pretty close. Yes.
Yeah, but could you get a vote, for instance?
Sure. Take a look at your governing documents, right? And oftentimes you don't necessarily need the approval of the board of directors in order to take that vote. You can do it at a membership meeting and take that vote at a membership meeting. And if that vote passes at a membership meeting, it may not necessarily require the approval in addition of the board of directors.
But my question is, you have no amenities and you're paying for them. How is that possible?
That's a whole different topic that you started out with.
It's a fact. It's a fact that we're paying thousands of dollars, and the pool hasn't opened for 3 years.
Why are you letting the board get away with that?
Yeah, that's
How come
the
you're not
reason
making them fix it.
He's leaving.
Well, part of the problem is that the pool is owned by 7 condos. And 7 condos. And so the others are not interested. But when Canadians come down, they'd like to use the pool in the wintertime. Nobody else.
Okay, so we're getting a little off topic here.
Sorry.
But no, that's just good stuff. So when you have an amenity like a swimming pool, right, and it breaks, and the boards make a conscious decision not to fix it, That's as if you made a material alteration
Oh, wow.
to the common elements. Well, think about it, right?
Yeah.
What would be the difference if you remove the pool physically? Isn't it, in a
Right.
sense, the same thing?
Right.
Right? So it's considered a material alteration to the common elements. And to do that, you would need typically a 75% vote of the community. If you're going to keep that pool in place and the unit owners are not going to take that 75% vote, then as a board,
It needs to
you
work.
must, end of story, you must make that pool work.
Sounds
End
like
of
they-
story. That's got to be fixed.
Sounds like they turned the pool into a pond. or
Right,
something.
right, exactly. That collects dirt and algae and it's now dangerous,
Oh, no.
right? Yeah, that sometimes happens when a bank takes over a home that has
Right.
a swimming pool, right? And they don't take care of the home and the pool accumulates dirt and debris and winds up becoming a very dangerous place for children to potentially wander off into. And you have to sometimes sue a bank to make sure they take care of the swimming pool, even at a private home.
Really?
So never mind in
So
a condo.
The bank is supposed to.
Absolutely, they have to take care of the property, yeah.
So do we need a lawyer to get the process going, because we're fighting with the
Well, how's your luck so
with the
far
board
without a
members. The
lawyer?
board members, a couple of the board members do not want a 50 change from 55 plus.
Yeah, well, I'm not going to sell, legal services for lawyers over there on this particular phone call. But like I said, you haven't had much luck doing it without a lawyer. So yeah, maybe your group wants to speak to a lawyer. That might not be a bad idea. Okay.
If you're asking if you need a lawyer, you probably do need one.
Yeah, that's. I like
Right,
that. I
right.
like that. That's a good bumper sticker.
It is, yeah.
Right.
Right.
Okay. So yeah, it's probably a good idea that you get yourselves an attorney to talk to.
So if you have a board meeting and you only have, let's say, well, you've got quorum, just a very small quorum. If that board meeting, if the members vote 75% to stop it,
Again,
then
I
you
don't know.
stop
Hold
the-
on. I can't give you an opinion specifically in that regard without seeing your documents. Certain questions on the show we can only answer if we actually have a copy of your physical documents in front of us. That's one of the questions. Okay. Sorry, buddy. We got to go
Thank
on
you.
to our next call. You be well.
appreciate it. Thank you.
Sure thing. Who else we got, Rob?
All right, let's go back to Ocala. See Linda.
Back in Ocala. Oh, Linda. Linda. Yes. Back to Linda. How are you, Linda?
Can you hear me?
Yes, I do.
Okay, we are not, thank you. We are not a HOA. We are governed, I don't know how. And that person who is governing us filed a paperwork for the 55 plus, but we're not an HOA.
I don't know
That
how to
legal.
answer your question. If you don't know who you are, how do I know who you are?
Are you a condo, 55 and over condo?
Sometimes I
No.
don't even know who I am, right? How do I know who you are?
I
Jackie
have no
Mason does a
idea.
whole
I have
routine.
no idea who
Yeah.
I am. I have been trying to find out the owner of the amenities filed the 55 plus, not the HOA.
I would love
not
to
an
answer your
HOA.
question, ma'am, but there's, again, another question where it's impossible to know what you are and how I can help you without seeing a copy of your governing
It's
documents.
a trick question.
It's a trick. Exactly. There's just no way for me to answer you, okay? Yeah, there's no way for me to answer you. I apologize. I would love to help you. Maybe if you call our office during the week, it's something I can put some time into
All
for
right,
you.
'cause it is an important question. He thinks he's legal because he filed a piece of paper.
I'd love to help you, but I can't do it right now, okay? You're going to have to call back,
Thank you, sir.
call our office during the week. Thank you. Back to the phones, Rob.
All right, let's go to Sarasota.
Thank you. Following up on my inquiry about where we keep the census we do every 2 years, we have 254 units. It's creating quite a fat file. How many years do we have to keep the census as the 2 years piles on?
Question is that a governing an official record of the association, and it certainly is. I would think it's an official record of the association. So it seems to me that's something that you have to keep for 7 years. Okay?
Understood. Thank you for
Okay,
clarifying.
thank you so much. Okay, keep the calls coming in, Rob.
So here's a question. Is there a difference for condos and HOAs for 55 and over?
No, not at all. Same
So
thing.
the
It's
lady that just
same-
called, it's the
yeah,
same.
right. Same thing. Yeah, the same statute the Housing for Older Person statute applies whether or not if you're in a condo or an HOA. Okay?
Right. Over to Green Acres, Florida. I have a question about
Wasn't that a
55 and
song?
over.
Green Acres is the place to be.
Right. I wasn't going to sing it. I'm glad
Farm living.
you did. Who do we got? That was Jaja, right?
Yeah.
Yeah, right? Okay.
Jaja Gabor.
Who do we got?
If you heard a beep, you're live.
Or if you heard us singing.
Good morning.
Yes. Good morning.
Yes, good morning. I'm calling from Green Acres, Florida. I live in a 55 and over community.
Okay.
And if your governing docs say you are a 55 and over community, then that means all occupants have to be over 55.
No,
correct?
that's not what it means, dear. We spoke about this earlier. Not all occupants. It means at least one occupant in every unit, and at least 80% of the units have to be 55 years of age or older. Okay, it does not mean every occupant, right?
Okay, so if you have somebody that is over 55
Right.
that had bought the unit,
That had what? Bought a unit, did you say?
bought a condo unit,
Right, okay.
okay, and they signed all the docs that they were going to be the only person in there when they did the interview screening.
Okay.
And then all of a sudden, a week or two later, younger people move in.
Okay, now how
What
old,
do
when
you-
you say younger people, how old are the younger
say
people?
Say it could be a 45-year-old mother.
So the 45-year-old, hold up, the 45-year-old by being there is not breaking the rule. The rule is when you're a 55 and over community, what does that mean? It means that you get to discriminate against children. Okay? It means anybody under 18, you can discriminate against them. Ordinarily, you wouldn't be allowed to discriminate against children, but if you're in a 55 and over community, you can discriminate against children.
They can visit, though.
Of course, they can visit. Absolutely.
Right, right.
Okay.
Okay.
All right. Thank you so much.
So there's a lot of questions about this.
Yes.
I think next week's show, we should do it
I
again.
think so. We love our 55 and over communities, right? Florida is all about that. And I always say, I remember as a kid growing up in Brooklyn, there would be red buttons used to make, right? You do the commercials for Century Village. Come on down, we have, that would be the line. Come on down, we have golf, we have tennis, we have arts and crafts, we have all these things.
And it only costs $200 a month.
$200 a month. And like I say, what did we find out? That, unfortunately after Surfside was, yes, it costs $200 a month plus your share of $30 million in assessments to fix it when it needs fixing. That's a real problem facing our 55 and over communities now. Those 55 and over communities that have waived reserves for years, if not decades on end. And maybe we need to talk about that a little bit, right? Next week too, right? What happens in these 55 and over communities now where unfortunately they don't have a reserve fund, but they're still being required under new law to have your mandatory reserves now, to have your mandatory recertifications, mandatory inspections, mandatory repairs. Has it become difficult, if not impossible, for many people to live in a 55 and over community, move into a 55 and over community, and to even live in the same 55 and over community that you've been living in for maybe the last 35 years of your life? Have you now been priced out of your own home?
If you're under foreclosure, does that count against the census?
If you're under, no, because if the house is not occupied, no.
Okay.
Yeah, if the house is not occupied, no.
No, but if you're living there and you're under foreclosure.
If you're living in the house and you're under foreclosure and you're 55 and over, then you're good. As long as the house is occupied by someone 55 and over, then you're good. Okay? And I think on that note, ladies and gentlemen, that brings us to the end of another week. So yeah, I think we'll stick with 55 and over communities for another week. Hot topic. A lot of people tuned in today. A lot of questions. Matter of fact, someone writes in and says, it's great that we actually wound up sticking with this topic all the way through. Yeah, it was pretty interesting,
Despite
right?
me trying to derail it. But,
exactly.
But we were going to do it last week, and people were tuning in for the 55 and over, and we didn't. And they're like, oh my gosh.
Exactly. So we'll stick with it next week. And if you need legal help off the air with not just your 55 questions, anything else that may be going on in your crazy condo and HOA world, give Glazer and Sachs a call in the office, 954-983-1112. Again, 954-983-1112. I wish everybody a safe, happy, and healthy week, and we'll see and speak to you again next Sunday on Condo Craze and HOAs. Be well, everybody.
Thank you.
Same truth, same time, no smoke, no spin. See you next Sunday at 11 a.m. You've been watching Condo Craze and HOAs. Lights coming down, another hour gone. Hard truths, lines clearly drawn. Process matters, rules come first. Ignore them once, and things get worse. Read the rules, show up in fun. When mistakes happen, don't take it personal. That's how lawsuits fade instead of grow. That's how communities stay in control. We take the calls, we hear it all. Helping Floridians stand tall. Condos, HOs, every voice has a place. When you face it head on, chaos loses the race. Same truth, same time, no smoke, no spin. See you next Sunday at 11 a.m. You've been watching Condo Craze and HOAs.